Good afternoon, everybody. Welcome to our seminar today. I got to say this was supposed to be my second presentation of the day, but my first one got postponed. I was supposed to teach at my daughter's elementary school. That was going to be significantly different subject matter than this one. This is a little bit of a dry but important topic, and something that I wanted to cover because I've noticed recently that I think this is being overlooked significantly by healthcare providers and by physicians and other folks qualified and being asked to serve as medical directors. So these are some things. I was speaking with a client recently that was in the process of recruiting to try and hire a medical director for a new clinic. And these are some of the things that we were talking about as we were putting that deal together. So here's our agenda for today. We've got 30 minutes, and we're going to talk about 5 things you need to know about becoming a medical director. And this is specifically, these are what I think the highlights and a couple of gotchas. And that's what we'll cover sort of in the next section here, what can go wrong. If you have questions, again, as always, please address them either through the chat box or shoot me an email or give me a call afterward, and I'd be happy to talk through the issues with you. So just as a little bit of introduction and background, Florida is one of the states that allows what's known as the corporate practice of medicine. So in some states, only a licensed healthcare provider can own a clinic that provides healthcare services. In Florida, a corporation that's not owned by specific healthcare providers can own a healthcare clinic under the Florida Healthcare Clinic Act, but there are restrictions, and one of the biggies there is that you need to have a medical director in order to have a healthcare clinic license. If you are a physician-owned practice, or if you have another type of healthcare practice, and you, or for some other reason, you believe that you are exempt from meeting the requirements of the Healthcare Clinic Act, you can apply for an exemption. And there are times that we'll talk about a case at the end where folks have done that, and it didn't work out so well because they were not honest in the representations that they made to the agency. It's the Agency for Healthcare Administration in Florida that's responsible for providing those exemptions or licenses. By the way, the corporate practice of medicine doctrine covers certain healthcare provisions of healthcare services. A healthcare provider providing, for instance, services by medical doctors can be owned by non-doctors and licensed under the Healthcare Clinic Act. But the same is not true across the board for all healthcare services, so I want you to be aware of that. For instance, dentists can only dentists can own dental practices. Only optometrists can own optometry practices. Although you will see structures where you have, for instance, a dentist who owns the practice, but then you have a management company that might be owned by somebody else other than the dentist, or the dentist and others, that leases equipment, does other services besides the actual dentistry service. But we're going to focus on healthcare clinics licensed under the Act, and specifically the big requirement here is that you have to have a medical director in order to get a healthcare clinic license for a clinic that's not owned by healthcare providers. So the relevant statute is section 400.9905, and that is the definitions section of the Healthcare Clinic Act that defines a medical director as a physician who's employed or under contract with a clinic, maintains a full and unencumbered license as a medical doctor, an osteopath, chiropractor, or podiatrist. If the clinic doesn't provide any of those specific services, it may be able to appoint another Florida licensed healthcare practitioner as a clinic director. Again, you would have to look at the specifics of what the requirements are for the practice. For instance, certain social services, psychology, psychiatry, and so forth. You would not be required necessarily to have somebody licensed. You wouldn't have a licensed chiropractor who provides services as a medical director for a psychology clinic. But again, these are the primary statutes that are identified, and the primary chapters for the professionals. The practitioner may not provide services as the medical director if those services are beyond the scope of practice of the practitioner's license. Again, you couldn't have, for instance, you would not have a podiatrist overseeing a surgical clinic that is beyond the scope of foot and ankle surgery. There are, again, I mentioned there's some narrow exceptions for rehabilitation and other exceptions identified in the statute. There's also several ways that folks can get exemptions, and so you'd have to look at the statute. Now, once you've identified a medical director, what do you need to do? The first thing is you have to have a written agreement between the clinic and the medical director. And amazingly, although this is very clear in the statute that you have to have this agreement, or you can have, in lieu of the written contract, you could have the medical director sign the ACA form medical director attestation that is in the available in the rules, and you can pull the form. I believe it's on ACA's website, and you can have the medical director sign that form. But the medical director has to sign, and the primary purpose is so that the medical director acknowledges in writing that they are accepting all of the responsibilities for overseeing the clinic, which includes all the statutory activities that are identified in the relevant statutes, and we'll touch on those in our next point. So you'll find these requirements. I put the rule sites in here, and if you want more information, if you have any questions about anything that I talk about as far as where the rules or the statutes, and I'll talk about a couple cases at the end, by all means, again, feel free to shoot me a message or an email or give me a call, and I can give you that. But here's the rule citation. It's Rule 59A-33.012 of the Florida Administrative Code pertaining to healthcare clinics. So third thing that you need to know after knowing who can serve as a medical director and knowing that you have to have a written contract is, this is another one that gets overlooked sometimes, is the medical director must be identified by conspicuous language in the clinic, and the clinic must publish and conspicuously post a schedule of cash payment charges for services. By cash payment charges, those are the regular charges that the clinic charges for services provided to people who just walk in the door and pay cash. And that has to be posted. The relevant Florida statute for that is, again, at 400.9935, subsection 1AI. Pardon me while I take a sip of water. And if the clinic doesn't do that, you can face a fine of up to $1,000 a day. So you need to have proper signing and signage and publication of the medical director and the charges that the clinic charges to cash paying patients. All right, now here's a big one. Number fourth thing that you need to know before becoming a medical director or about being a medical director is first thing of this list is going to be a list of things that we'll hit on here. The medical director is responsible for the day-to-day supervision of the healthcare clinic. All too often, we see situations where somebody is serving as a medical director or asked to serve as a medical director, and it looks like a nice side gig, but they're not visiting the clinic, they're not on site. They can be available to answer questions, but somebody wants to use their name essentially just to be able to get a healthcare clinic license, and so they approach somebody who's qualified, such as a medical doctor, and say, hey, I'll pay you X to be the medical director for my clinic. Can I use your name and have you sign this agreement? And you don't have to do anything. We'll just agree to pay you X amount of dollars, and you get paid for being the medical director. Well, that sounds like a great gig. The issue there is that you need to understand, if you're that physician who's signing up for those responsibilities, you are now accepting legal responsibility for the compliance of the clinic. This comes back to the written attestation or written contract requirement that you've now agreed that you're going to oversee compliance. This includes such things as record keeping and billing and so forth. These are all things that we've listed below here in the slide. You need to ensure that all practitioners providing services or supplies maintain a current and unencumbered license in Florida, and that they maintain their appropriate licensing and certifications. So not only are you responsible for yourself and your name's on the door for the clinic, but you also have to make sure that everybody who's in there providing services does what they're supposed to be doing as far as their licensing and certification. So for instance, there's a case, I'll tell you the name of it, I don't have it here in the materials, but a couple of years ago there was a case called, might be one that we're going to talk about later. The plaintiff in the case is State Farm. Oh, I've got the case. Actually, we are going to talk about this case, but State Farm, the B&A Diagnostic Institute. This was a case down in the Southern District of Florida, in South Florida. It was a federal case brought by State Farm, where State Farm sought judgment against this clinic with an order to not have to pay fees and other charges to the clinic that were billed through insurance because the clinic was not in compliance with the relevant statutes and rules. And one of the things that happened there is that they had a person operating an x-ray machine who was not properly licensed. There was another person who was operating the x-ray or operating another machine, and they were, again, not properly licensed and supervised. In one circumstance, the person who was operating the machine was required to, could only operate the equipment if they were being supervised by a physician on site. And the physician was never on site who was serving as a medical director. The medical director wasn't aware of the requirement. The physician medical director admitted to not being on site for regular supervision. And so the person who was performing the x-ray services on the patients was operating in violation of the statute, and that comes back on the medical director who's responsible for that activity. Another big one here is that the medical director is required to oversee billing, and that includes what I've put in red here, conducting systematic, and this is right out of the statute, you're required to conduct systematic reviews of clinic billings to prevent fraud. We are seeing an uptick. We've been seeing it for a while. We've seen them in PIP cases, particularly the Florida personal injury cases, mostly involving auto accidents, where the cases are brought by personal injury lawyers for claims arising out of an auto accident, and the patient goes and receives services. And we have these auto insurance companies who have been suing the healthcare clinics providing the services, saying that the clinics have not been properly billing for those services because they're not operating in compliance with the rules and requirements that apply to the clinic. And for that reason, they don't need to, the State Farm or the insurance company, whoever brings the case, doesn't need to pay for those services. And they have been winning those cases. Not only that, we are now seeing new situations where medical directors and other physicians are being sued. In fact, I won't go into detail on the case. We have a case ongoing right now where we are representing a couple of physicians in a case where an insurance company has brought a claim for fraud and a fraudulent conspiracy and claims under RICO, the racketeering, the federal racketeering statute, Racketeering Influence Corrupt Practices Act, alleging that all of the monies that were paid by the insurance company for member benefits was paid as a result of the fraud perpetrated by a conspiracy between the provider and the physicians and other players who were involved, and now seeking to recoup all of that money that was paid, plus seeking a determination that they don't have to continue to pay for these services and charges, and seeking, in some circumstances, in the case we're involved in, they're seeking punitive damages and other damages, alleging that everybody was involved in a big fraud to defraud the insurance company. With cases like that, again, it doesn't matter. Of course, it matters if what the outcome of the case is. But if you are a professional providing services and you are named in one of these cases, it is an automatic black mark. It becomes a public record, and you are not going to be able to escape this. So even if you are perfectly innocent and you've done nothing wrong and you are sued in one of these conspiracy cases where everybody is netted up and wrapped into the same net and painted with the same brush with the same broad strokes, you run a risk being involved in a clinic that's not operating completely properly. So since we're seeing that, I think it's really important for folks to understand that, again, taking on a responsibility as a medical director, you are taking on a lot more than just putting your name on the door and receiving payment for that. Again, I flipped over here onto the next slide. Any patient referral agreements, you need to review those. You need to be on the lookout for unlawful referrals, anything in violation of the Anti-Kickback or Stark Act or under the federal or Florida Patient Self-Referral Act. If you have questions, then you should have counsel review those. If you're a physician and you're serving as medical director to a clinic, and that clinic is paying you to oversee these activities, you are not a lawyer. You are a physician, and nobody, reasonably, in my view, is going to expect a physician to read through the rules and read through the statutes and make sure that everything that the clinic is doing is legally proper. You need to understand from a factual standpoint what's happening, but you should not be bashful about making sure that the clinic has legal counsel, and this should not be a physician expense or a personal expense for the medical director. This should be a clinic expense. The clinic should have counsel that reviews these issues from a legal standpoint and make sure that you're in compliance. So that's a big tip. If you are a medical director, make sure that the clinic that you are serving for and whom you've signed a contract with either hires counsel or gives you a budget so that you can hire counsel to make sure what you're doing is proper and review, again, review the billings, review the referral relationships, review the licensing and compliance issues. There are certain no-nos that are spelled out right in the statute. Another one of these State Farm cases, again, involved x-rays. The statute says that you can't refer MRIs, you can't PET scans, CT scans, and some of the violation activity is considered a felony under Florida law. So again, you look to Florida statute 400.9935 for all of this. We'll move on to number 5, the 5 things you need to know before becoming a medical director. Number 5 on this list is that there is maximum numbers that are spelled out in the statute. The medical director can serve in that role for no more than 5 clinics with a cumulative total of no more than 200 employees among all of the clinics, and all of the clinics must be within 200 miles of each other. So when you think about, I put this one last because when you think about the requirements for what you really need to do in order to be fulfilling your responsibilities as medical director, it'd be tough for one person to do this for several clinics spread out throughout the entire state of Florida with several hundred employees. So there's a limit that's in the statute, and that's found in the administrative code. So some of these things you'll see are found in statutes, some are found in the administrative codes, and then sometimes we get further interpretations of specific rules, laws, statutes through cases that find their way through the state or federal court system. So I mentioned the PIP cases, and it has been pretty well firmly established now, even though the statute may not spell out a private cause of action or private right of action. And I'll back up and explain what that means in a second. But even though there's no private right of action spelled out in the statute, these insurance companies have been able to bring these claims against clinics that are operating unlawfully and have success in having not only outstanding billables scratched off and down to 0 or gotten an order that they don't have to pay them, but also gotten recoupment from not only the clinics, but from the employees of the clinic, including the medical director, to the extent that either that employee or medical director was paid improperly. So there's what's called an unjust enrichment claim that basically says you were paid X amount of dollars last year for being the medical director. Your responsibilities were this. You were supposed to make sure the clinic was operating in compliance, and you failed to do that. And because you failed to do that, you didn't do your job. Because you didn't do your job, you weren't entitled to be paid. You were paid $50,000. You now have to get that $50,000 back, and you have companies, these insurance companies, that are going after that money. So if you think that one sounds bad, not only do you have a situation where you could end up having to give back all the money that you were paid, but if you get sued in a conspiracy action, you can now be facing a claim where, again, I'm seeing these by insurance companies, where the insurance company is saying, as part of the conspiracy and in helping to further the conspiracy, the insurance company has shelled out, let's call it $2 million over the past year, or $5 million over the past 3 years for billings and claims that were improper because the clinic was not operating legally. And the physician who signed up to be the medical director, or the physician who signed up to provide the services, knew that the clinic was operating improperly, but went along with it anyway, was part of the conspiracy to improperly bill the insurance company. And now those employees, including the director and any other physicians and providers, should be held jointly and severally liable for the whole amount due to State Farm. So if State Farm is seeking $5 million back from the clinic, they're trying to go after, and I'm using State Farm, but I've seen it with Allstate. I've seen there's other insurance companies, but I have a State Farm case I'm going to talk about. They're going to go after that full amount from everybody and collect from whoever they can get from. And on top of that, they're going to try and go after punitive damages in some circumstances. So this can really be a situation where you have a lot more at risk than even what you were paid. So, what's your time worth? What's all the stress worth? And what's the risk that you face when you take on these responsibilities? I by no means want to discourage anybody from doing this. I have several clients who do serve as medical directors. I also represent clinics who have medical directors. The fact that we have this ability in Florida, every state doesn't have that, where you can have a healthcare clinic that is not owned by the providers, but is owned by a separate entity that hires the providers. I personally think that's a good thing. It allows for a greater ability to separate out the business of healthcare and the providing of services, which is good. Some people are good business people and some people are good providers, and they're not always the same folks. But what comes with that privilege that we have here in Florida is the responsibility to make sure we're following the obligations in the statute. So let's take a look at this case here. We'll say, what can go wrong? Well, we'll touch on a couple of these, but in this case, this State Farm v. B&A Diagnostic. I'm looking at my time here. I have a few minutes I can discuss this case. I want to pull it up here. State Farm sued a clinic. They sued 2 different physicians, at least 2 different ones from what I can see from the case, that had agreed to serve as medical directors at different times. So this covered the span a few years. And they also sued a couple of the employees for, this was the case where they sued them for providing the x-rays. Here's some highlights from the case. What happened here is the first physician who signed on to be the medical director was there for just about a year. And then there was a second physician that came on, and during that time there were 2 employees who were providing x-ray services. One was not properly licensed at all, and then another employee had a certification but not proper license to operate the equipment on his own. In deposition testimony, apparently, one of the doctors admitted that he didn't conduct systematic reviews of billings. He never reviewed the statute. He wasn't aware of the requirements that we've talked about today in 400.9935, and admitted that he was unfamiliar with those requirements. And he assumed that the bills were lawful. He testified because he said, and this is a quote, "Billing is just billing." And so he never looked at it that closely. Another big no-no was the clinic in this case was routinely waiving co-payments and deductibles, and that's a big no-no. It's a violation of Florida's insurance statutes. A clinic cannot routinely waive co-payments and deductibles for patients. It can be considered in some circumstances insurance fraud. It can also be considered in some circumstances a violation of the anti-kickback statute, both at the state and the federal level. So you can't just, as a matter of routine business practices, waive your deductibles and co-pays. He admitted that he never checked to ensure that the folks providing the other employees were properly licensed and certified to provide the x-ray services, and he did not review the billings for x-ray services that went out from the clinic. The court found that one here, as we list in the slides, the medical director failed to meet his basic obligations as the medical director. And the x-ray services that were referred internally were not lawful. They violated the statute, and other x-ray services that were provided by unqualified employees were not lawfully paid. And then I mentioned this earlier, the unjust enrichment claim. Any payments that the insurer made were the product of unjust enrichment because the statute would only require the insurer to pay for services that were properly provided by a clinic that was in compliance under the statute. Here's what gets interesting about this case as well is, in this case, the plaintiff went back several years to try and recover for what the plaintiff called were essentially improper or fraudulent charges that were done in violation of the statute. One of the defenses that was raised by one of the physicians, a good defense, was statute of limitations. You can only go back for a certain period of time after which your claim is time barred. But the plaintiffs made a good argument here. They argued that the statute of limitations was what we call a toll. There's this concept of equitable tolling where if you have a claim but you're not aware of the claim because it is willfully, the rights under that claim. A common would be if somebody lies to you and commits a fraud and you suffer damages, but you're not aware of it until a later time. Somebody steals something from you that's locked away in a safe and you don't find out about it until 5 or 10 years later. The statute of limitations is run, but if you had no reason to know about it, and especially if the person who stole from you or lied to you went out of their way to lie to you, tell you, oh yeah, I left all the monies in the safe. I check it every day. It's always there, and they're signing off on a little log that says I'm checking this and everything is good. That you have a right to rely on that, and if you later find out that it was untruthful, you can bring up this concept called equitable tolling to toll or stop or pause the statute of limitations. And here, what the plaintiffs argued in the State Farm case was that when the clinic filed for its license and did its annual filings, and when they submitted, first of all, when it filed for its license, it said it would comply with all the requirements under the Healthcare Clinic Act, and it didn't do that. And that was a fraudulent representation. And then further, when they submitted payments, submitted charges for payment to State Farm, to the insurance company, they signed off on those charges, and they represented that those charges were the result of proper procedures, proper billings, and the charges were properly payable, and the clinic was in compliance with the requirements under the Healthcare Clinic Act and all of the requirements under their contract with the insurance company. All of those representations were improper, and they were essentially fraudulent representations because the clinic was not in compliance, and the court agreed. And so the court said that the time period that had passed did not cause the statute of limitations to kick in because the plaintiff's right to bring those claims were equitably tolled, and they were allowed to bring the claims at a much later date. So that case represents really, what the end of that case. I'll tell you what the defendants ended up with. The physicians there, from what I gather, sometimes when you read these court opinions, it's not exactly clear what's happening, but reading between the lines, the total claim against the clinic was over $1 million. It was somewhere in the area of, when I add everything up, it looks like probably about a little over $800,000 against the clinic itself, with another $700,000 the court ordered were outstanding charges that State Farm didn't have to pay. So we're looking at $1.5 million against the clinic. Each of the physicians were hit. One was hit for over $300,000, and the other one was hit for almost $200,000. And because that's less than a total amount, and I didn't see a conspiracy claim, the way I read that case is they probably were required to put back any money that they had gotten from the clinic as pay or other compensation because it was an unjust enrichment issue, and so they were not entitled to keep that pay, and they had to put it back. The other employees, by the way, they didn't get off either. The folks who were one of the defendants, the one who was not properly licensed to provide x-ray services, was required. I looked at a judgment of $44,000 almost. And then there was another defendant who got out of the case early, so we don't know what happened. Presumably that defendant settled. So this is just one case. There's a couple other cases. If I had time, I'd go into them a little bit. I do want to just mention, and we're going to close up here, but there's another case called, give me a moment here, State Farm v. First Care Solutions. And this one was notable because, and I've seen this situation before, I'm not a licensed healthcare provider, but my son, daughter, cousin, somebody else is. And someone said, look, I'm going to put the company in your name, and then that way we can get an exemption. We're not required to get a separate medical director, and we'll run the healthcare clinic. And that's what happened in this other case of State Farm v. First Care Solutions, is they tried to say that the company was owned by somebody who didn't actually own the company. And that's always a big no-no. It's pretty easy to go back and look over a period of years and find out, who's on the tax returns or the K-1s, who's reported as the taxable owner of the company. Look at operating agreements and other documents. Who's got the authority to make decisions on behalf of the company? Who has the keys? Who hires and fires? Who signs all the contracts? There's all sorts of things that we can look at to find out if somebody is really the owner of a company or not. I'll have to have folks sometimes suggest that you can look on Sunbiz and see who the manager is of an entity. Sunbiz is what we have here in Florida, where the corporations and limited liability companies and other entities are listed for public view. Sunbiz only requires you to list one manager talking about a limited liability company where most entities operate now. You're only required to list one manager. You're not required to list members. You're not required to list all the managers. So oftentimes companies, a lot of my clients will only list one manager. Oftentimes that manager might be another company, might not be an individual. But that doesn't mean that that's the owner of the company. It's not indicative of who the owner is. If you go on and you look and you see managers listed, it doesn't mean that that person owns any interest. You can certainly be a manager without being a member. But this game where folks want to own the clinic and then say that somebody else owns it in order to avoid licensing, that blew up in the face of the defendants in that other case, that First Care Solutions case. In a 2017 opinion, the court came down on the healthcare clinic. The person who was the real owner of the clinic that got hit for a judgment, and two other individuals who at different times had allowed their names to be used. They were healthcare providers who allowed their names to be used as the owner of the clinic for purposes of filing with ACA. So again, big no-no. So to conclude here, understanding that our demand for medical directors, for healthcare services in general, and medical directors in Florida is high. And as a practitioner, or if you're representing a practitioner, it will not be, you will see commonly folks get asked to serve as a medical director, and I would like folks to understand that when that opportunity comes about, or when that role is presented, that there's legal responsibilities that come with it. And we have this little rhyme here: when in doubt, seek counsel out. So that's our conclusion of our first 30 minutes for this month. Thank you again for joining us. See you next time. Bye-bye.